Hello, everyone. Thank you for joining us today for this webinar that will be looking at the True Freedom Act of 2020 and providing some updates on filing for criminal record relief in Maryland. We have a lot of people joining us right now, but we do want to get started because we have a lot of information to share with you today. My name is Heather Heiman, and I am here with my colleague Jessica Emerson, the director of the Human Trafficking Prevention Project. I am the managing attorney of the Human Trafficking Prevention Project here at MVLS, and this project is a partnership between University of Baltimore School of Law and Maryland Volunteer Lawyer Service. Many of you, I hope, have tuned into some of our past webinars. We host a quarterly series looking at intersectionality of human trafficking and other legal issues. And like I said, we are very excited to have you with us today to celebrate the passage of a very important law. So before we jump into our agenda, I'd like to just do a few housekeeping notes. We've divided the presentation today into two parts, which you'll see. And I just wanted to note the first part of the agenda will be covered within the hour. We are going to be looking at the changes to the law and some other options for criminal record relief here in Maryland. And then for those of you that may not be familiar with Vacatur, we are going to be having a part 2 where we'll go through in a little bit more detail how to actually vacate a conviction for survivors of trafficking here in Maryland. Those of you that are familiar with the process or have listened to our past webinars, this won't really be new information. It'll be just updated in reference to the new law that was just passed. And we will be pausing after the first part to take any questions, though I will also be looking for questions throughout the presentation. And we also have the PowerPoint saved as a PDF that you can access through GoToWebinar, along with an additional document, the new Maryland court form for a petition to vacate a conviction. And we will also have this presentation available on MVLS's website. You can see the recording here and listen to the recording later, and also access associated materials. But with that, I would like to just give a moment for Jessica to say hello and welcome everyone.
Hi, everyone. I'm so glad you could join us. Again, I'm so excited to present this information. The True Freedom Act is a long time coming. We had a lot of great advocates and partners in the fight to get this law passed, and we are really excited to present this material to you. Just want to say thanks to MVLS as always for being our partner and for hosting and really taking most of the weight on putting these webinars together. So thank you, Heather.
Of course. All right, so we're going to jump into the first part, and we will, first just briefly be touching on why criminal record relief for survivors is so critical. I hope everyone that's joining us today has some understanding of this, but we always feel that it bears repeating because this is sometimes an overlooked aspect of survivors, of assistance we can provide survivors. And, it's not in the beginning with kind of crisis intervention or making sure they have, mental health support or other things that people might think of as the immediate needs for trafficking survivors, but it can be so critical to enable them to move forward with their lives in safety. And so we always like to touch on this whenever we're talking about, vacature, expungement, or any other criminal record relief option that someone might be considering pursuing. So as you can see, conviction and arrest histories can really impact survivors. I see it in almost every person I work with who is trying to find new employment or a job. The first thing that employers do is look up, Maryland case search history online, and they can see if somebody's been arrested, if somebody has past convictions, and that can often lead to somebody not getting a call back, let alone an interview for a job. It can also prevent someone from receiving housing assistance. It can be incredibly difficult to get student loans if they have certain types of convictions and prevent survivors from pursuing their education, and also set up roadblocks for obtaining public benefits that so many survivors need to, again, be able to move forward with their lives. In the long term, it can impact a survivor's ability to access credit or apply and successfully receive loans. Because again, looking at someone's criminal history, just like with all the above categories, can be something that someone is looking at when they're evaluating a survivor's eligibility for some type of benefit. It can also impact family stability. We've worked with so many survivors here at MVLS that have been embroiled in contentious child custody disputes, or would like to get a divorce, or have some other issues where that survivor's criminal records is going to have a direct impact on the court hearings that they might be involved with and the legal matters relating to these family law disputes. It can also have a huge impact on somebody's ability to access immigration relief or adjust their status. And this is a particular place where the difference between trying to get expungement and trying to get vacature can really impact somebody's ability to get immigration relief. Vacature is in itself a much more comprehensive remedy for the survivor and can remove some hurdles that they might otherwise face if they're seeking status in the United States. Finally, and I think most importantly, addressing criminal records can really help a survivor heal from trauma, particularly vacature. Having the court admit that they made an error and that the survivor should have been receiving assistance instead of criminalized because of their experience is an incredibly powerful thing. And so we want to be sure that we're offering criminal record relief and connections, referrals, legal options to everyone that we're working with that may have been trafficked.
And Heather, just a little reminder about the past slide. It says conviction and arrest history for a reason. If a survivor has quote unquote just arrests on their record, that can do all of the damage that Heather just went through, even though it's not just convictions. So it's really important to remember it's not just convictions, it's arrests and intersecting with the criminal legal system in any way. So we want to take you through the evolution of criminal record relief laws for survivors. So this is what the US map looked like in 2010. You'll notice that only my home state of New York is lit up in this one. And that's because New York passed its law in 2009, went into effect in 2010. And it was the first state in the country to recognize that survivors were being held back by having criminal records. I have an updated 2020 map, so it actually is bigger and brighter than the one you've probably previously seen. But this is, oh, there we go. Sorry, we're trying to figure out how to share the mouse. So this is what the map looks like in 2020. And you'll notice that the majority of the country is RNG, and that means that these states allow for vacature or expungement of charges. And then the pinkish states, they only allow sealing, which is not a complete form of relief, but it is something that is harm reductive in nature. And we've got 5 states only five states only that do not have any form of criminal record relief on the books at this time. Now, this map is coming together nicely, but what we also have to remember, even though you're seeing all these states lit up in orange and pink, every state's law is different. And in March of 2019, I participated in putting out a report along with Polaris and Brooklyn Law School on criminal record relief laws across the country. And so this was really an attempt to encourage states to more uniformly adapt criminal record relief matters, because even though Washington has vacature and Maryland has vacature, it doesn't necessarily mean that what is eligible is similar, that the procedure is similar, that the access is similar. And I think it's really important that in this day and age that we point out, when we think about the anti-trafficking movement within a racial justice framework, which is, in my opinion, how anti-trafficking work should be approached. When you think about it in terms of a racial justice framework, you can see based on my description that even though all these, orange states are orange, they're not necessarily equivalent in terms of access. And you can see how even these laws will disproportionately affect people of color because people of color are disproportionately affected by trafficking. So again, just thinking about the lack of uniformity across the states, that is something that should be factored into a racial justice analysis of criminal record relief laws in the anti-trafficking world.
And turning back to vacatur, we wanted to first take a look at the definition and then discuss a little bit about what the law was here in Maryland to ground everyone and make sure that then we can go on and do a thoughtful analysis of now what the law is. So the definition of vacatur is to undo a court's judgment, and it basically returns the petitioner to the place that they were in prior to the conviction. The court is completely setting aside that conviction, and it is different from other forms of post-conviction relief that's available here in Maryland. It basically means, again, that there was an error in that original judgment, and as I said earlier, it is an acknowledgement that the court should have not been criminalizing the survivor due to their experience. And it's really important to note, as Jess touched on, that while the different forms of criminal record relief can help people, they can enable them to be able to access employment, access housing, access their types of benefits. Vacatur really contains that additional emotional benefit of acknowledging that the law made that mistake. However, like just said, we do want to remember that vacatur is not the only form of criminal record relief available to survivors. Again, here in Maryland, many of the people that we work with through the HTPP, they have a combination of things on their records. They may have some convictions, but they also may have arrests that were null pros. They might have received a stat, a PBJ. They might have received a probation before judgment. They might have received different types of outcomes and decisions in their different legal matters. And so we need to look holistically at what we can do for clients. And usually it's a combination of things. Usually we're working potentially with expunging things as well as vacating those convictions that are eligible. And now we're of course able to do that with a larger number than we were before. So Maryland's prior law, which was one of, I think it was the worst in the country of the states that had laws. That F grade was looming large over the state after the 2019 Polaris report. It was extremely limited. Again, and this is kind of the core reason why it was so limited, and one of the things that was addressed with the True Freedom Act this year. The grounds for a motion to vacate judgment, it was really only based in a conviction for prostitution. If you had a conviction for anything else, you could not vacate it. And this extremely limited remedy really gave for survivors few options. And that was incredibly problematic and one of the biggest things that was addressed by the change in the law. As you can see, the prior law had these different rules around the form and the contents of the motion. It had to be filed in writing. There was this incredible hurdle of having the motion be signed and consented to by the state's attorney, which is an incredibly intimidating thing for not only survivors, but for attorneys and advocates, to think that you have to go and get this approval before you're even allowed to file the petition with the court was really, in our opinion, kind of a miscarriage of justice around the way this law was constructed. You had to make the petition within a reasonable period of time, and then of course include evidence and documents that would show that the petitioner was entitled to the relief under this section. After you would file the petition for vacatur, there would be a hearing, and under the old law, there had to be a hearing on the filed motion according to the letter of the law, and then the judge would rule, and the burden of proof was on the petitioner under the old law. So now I'm going to hand it off to Jess to talk about the changes to the law that have happened with the True Freedom Act of 2020, which went into effect just this week, excuse me, on June 1st.
Yep. All right. Thanks, Heather. All right. Let's talk about the True Freedom Act. There are a lot of different changes. What we're going to do first is just go through the law, and then what we did was underline some of the things that we're going to talk about in greater detail once we get through the actual language of the law. So the grounds for motion to vacate, so what you need to have in order to be able to petition to vacate a judgment, you have to be convicted of a qualifying offense, and that qualifying offense had to be as a direct result of someone being a victim of human trafficking. One of the big changes that we requested and that we got was that the definition of a victim of trafficking was changed. Heather highlighted that the only conviction that was eligible was a conviction for prostitution. So that essentially limits, in most cases, the relief to sex trafficking survivors. And this law opens things up. So the definition of a victim of human trafficking within the True Freedom Act is that you meet the requirements of, obviously, Maryland's trafficking statute, or these various portions of the federal code that include forced labor, trafficking generally, sex trafficking, and attempted trafficking. So what this does is this opens up the law so that survivors of labor trafficking are now eligible as well. All right, let's go through some of these qualifying offenses. There are a lot of them, but we just want to kind of put a few in context and help you see some of the patterns. Obviously, at the beginning, you can see lots of drug-related offenses. That is, I have to say, what I see primarily as accompanying prostitution on the clients that I've worked with records. So there's controlled dangerous substances, non-controlled dangerous substances, and possession of paraphernalia. Those are three really common convictions that we see on survivors' records. Fourth-degree burglary is really important because that's probably the second most common thing that I see on folks' records, because it's essentially squatting, and it is what a lot of people experiencing homelessness need to do to survive or to earn money while they are being trafficked. We move on to destruction of property and trespassing. Misdemeanor theft, incredibly common. So many of my clients shoplift for their own survival or for their children's survival. So having misdemeanor theft, being able to vacate misdemeanor theft offenses was huge for us. And obviously, Heather, jump in with any other examples. We've got some bad check offenses. We've got possession of a fraudulent government ID, so somebody who has somebody else's ID, things like that is really common. False statement to a law enforcement officer, that can simply be not giving your actual government name. And we go across the board to disturbing the peace, indecent exposures, really common for us. Obviously, prostitution is still included. And then we go through to a pretty large list of transportation article offenses, because we really commonly see survivors who are driving without a license because they lost it, or they never were able to get it, or their trafficker forced them to drive them because they don't have a license, or having a suspended license. These are really common occurrences in the lives of survivors, and so this would allow us to actually get those convictions off of a survivor's record. And then the one that I want to point people's attention to is the last one, that prostitution or loitering is prohibited under local law. I see almost exclusively with our transgender clients that they are charged with prostitution or loitering under Baltimore City Code. And I mean, I have to say, I have never actually seen this with a cisgender client. But we weren't able to do anything about those charges on someone's record. And now we would be able to, even if someone was charged under Baltimore City Code with prostitution or loitering.
Jess, before you skip to the next slide,
yeah.
I just wanted to make another comment that what really struck me, you know, as advocacy for this law was going on, and now just seeing this huge list of things that can be addressed through vacatur, is it's also so important because of the lack of other legal remedies for some of these different things. And if you look at this list, it's a mix of some things. If you have convictions for some of the items on this list, you could potentially eventually get them expunged, some things, but you would have to wait 10 years and not have any subsequent convictions after that initial one, or you'd have to wait 10 years after any conviction, because they can begin to cascade, and oftentimes the survivors we're working with have had multiple convictions that then pushes them out from being able to get relief, to almost a decade. And some of these things, though, when I was going through records with clients, once I saw, some of these things like false statement to a law enforcement officer, or, driving under with a suspended license, we kind of knew that anything that might potentially be expungible in regards to convictions was then going to be blocked. And so this incredible list, and again, the advocacy that was done by survivors and advocates, throughout the years to get this all included, like this is really going to make such a difference in people's lives, because for many of these different convictions, there was just no option at all for relief.
Right. All right, so let's go through the procedure for the True Freedom Act. So similar to the previous version, obviously the motion that's filed needs to be in writing. It needs to be made within a reasonable period of time after the conviction. It has to again describe the evidence and provide copies of any documents that show that the defendant was convicted while they were being trafficked. And then we've got some changes, and I'm not going to talk too much about them because we're going to talk more about them in a couple of slides. But obviously we've taken out that signed and consented and replaced it with it must be served on the state's attorney in the jurisdiction where the conviction occurred. And then we have, with some feedback from the victims' rights and advocacy community, some of these convictions, I just want to pop back, some of these convictions may have had victims. So if there's a malicious destruction of property, I destroyed somebody's property. So there may actually be a victim in some of these crimes. And so we worked in a portion of the law that says if the qualifying offense occurred within 5 years before the filing of the motion, there has to be notice mailed to any victim or victim's representatives to make sure that they know that they have rights in a say in whether or not someone is provided access to this form of relief. They get to actually have a say. And this is a nice compromise because, within 5 years, somebody is more likely to be at their previous place of residence. And then that we're not trying to contact people 20 years after, a destruction of property conviction. So it's if the qualifying offense occurred within 5 years before the filing of the motion. Ruling on the motion, the court may grant a motion on a finding based on preponderance of the evidence that the movement committed the qualifying offense as a direct result of being a victim of human trafficking. But when making a finding under this section about whether or not this qualifying offense was a direct result of the individual's trafficking experience, there's a number of factors that the court must consider, shall consider, which is the length of time between the offense and the trafficking of the movement, not the movement, the dynamics of the relationship between the movement and the person committing trafficking against the movement, and any other relevant evidence that might kind of go into the court making this decision. And again, we're going to talk in greater depth about that. And there, like Heather said, in the previous iteration of the law, the court had to have a hearing. And that can, for some survivors, be incredibly gratifying, being able to stand in front of a judge and have the judge directly address, their trafficking history. But for some survivors, they really don't want to do that because being in the courtroom and being exposed to lawyers and judges again is incredibly traumatizing. So this iteration provides that there may be a grant without a hearing. So the court may grant a motion without a hearing if the state's attorney consents, if there's no objection to the relief by the victim or the victim's representative, and at least 60 days have elapsed since that victim or victim's representative has been notified of the filing of the motion. And likewise, the court may dismiss without a hearing if the court finds that the motion fails to assert grounds on which relief may be granted. They're just not eligible. The person wasn't being trafficked at the time that they were convicted. If there was a subsequent motion filed and the court is reconsidering, if the motion offers no additional evidence beyond which the court's already considered, they can dismiss without a hearing. And if the movement acted fraudulently or in bad faith in filing the motion. I do have to say though, in working on these cases since 2011, I have never in my life seen anyone attempt to fraudulently or in bad faith attempt to gain access to this form of relief. But I understand, the sentiment behind it. Obviously, we don't want anyone to be acting fraudulently or in bad faith. Another change, if the court grants the motion, they shall vacate the conviction, and the court shall state the reasons for its ruling on the record. Burden of proof hasn't changed. If a former defendant is trying to challenge their conviction, they have the burden of proving that it was not, that it was actually as a result of them being trafficked. And this is an awesome new section. So a conviction that has been vacated under this section may not be considered a conviction for any purpose. So let's break some of those things down. Qualifying offenses, obviously, we've gone from prostitution to nearly an A to Z list. And as Heather stated, a number of these convictions would eventually be eligible for expungement under the Justice Reinvestment Act, but that's a 10-year wait with no subsequent convictions. So this offers survivors more immediate access to relief, and that's critical in their recovery in many cases. I will say that one of the challenges with a kind of delineated list like this is that sometimes you'll find things that fall a tiny bit outside of the one conviction that's allowed. Like for instance, there's more than one way to possess a particular type of paraphernalia. And so sometimes you may find on your client's records that some things fall a little bit outside of this delineated list. And if that happens, please do contact us because there are kind of ways that we can try to address these things. So even if you see something that's not exactly perfectly aligned with these qualifying offenses, we'd like you to contact us anyways. As I said before, labor trafficking survivors are now included. So even if someone has not been trafficked for sex and they have a trespassing conviction on their record, we want to make sure that they're contacting us so that we can now petition for relief for labor trafficking survivors as well. We eliminated the consent requirement. Essentially, the new law now aligns with criminal procedure law in Maryland, where we have to serve, obviously, the state's attorney. The state's attorney has a period of time to review the motion and to object if they feel that the person does not qualify for relief. And so this may result in hearings on these motions, but we won't be doing our business any differently. It's really important as a form of best practice to make sure that you are collaborating. And I say that word very deliberately, collaborating with the state's attorney on these motions. It really is another form of healing for the survivor to see that both their attorney and the body that prosecuted them are working together to effect justice for them. So we, as soon as this law passed, Heather and I got right on the phone with one of the state's attorneys that we work with, and we worked through, how are we going to do this going forward? And so it's really incredibly important that even though the consent requirement has been eliminated, and rightly so, we're not going to be doing the things that we do any differently. We're still going to prioritize working collaboratively with the state's attorney's office. There is that victim notification requirement. As I said, some of the qualifying offenses may have a victim. And so it's important that victims get the chance to participate in the process if they feel the need to. We talked about the direct result. Direct result in terms of kind of the range of language that criminal record relief laws throughout the country use. Direct result is not my favorite, but I really like that there is an opportunity to qualify that direct result, right? So it's the nexus. How closely associated is the conviction to the person's trafficking history? but then qualifying that with the dynamics of the trafficking relationship. So if I've been trafficked for 10, and again, I'm generalizing here, you know, with a violent trafficker for 10 years, it's going to take me some time to, you know, to start the recovery process. And so there might be convictions that are a little, you know, further attenuated from my trafficking history. But if you qualify that by the dynamics of the trafficking relationship, we can kind of think about this direct result in a different way. And then any other relevant evidence. And this is really crucial. Obviously, it provides guidance to judges, but it also provides guidance to those of us who are doing the work, because, you know, we can think about how to navigate and to explain this information, because we're really kind of helping the court see what direct result looks like, and that it doesn't look the same in every single case. Judge can grant a motion without a hearing. Obviously needs the consent of the state's attorney, no objection from the victim, any potential victim in the case, and 60 days from service if there was a victim notified. And like I said, this is crucial because not every survivor wants to go into the courtroom. We're a little unclear about who's responsible for providing the notice to the victim's advocate, but all of these things will be worked out in time. I mean, this is new for all of us. And Heather and I we're talking about a law we haven't practiced under yet. And so, you know, I'm sure there's going to be questions that come up with, you know, a lot of these different requirements, but this is one kind of blatant one that we're not quite sure about yet, but we are asking for guidance on this. The judge can dismiss a motion without a hearing, like we discussed. And then in the previous iteration of the law, the judge was given great discretion in what they could do if they decided that the person was eligible for relief. They could have vacated the conviction, they could have granted a new trial, or they could have altered the sentence. And that area of the previous law provided discretion that was far less helpful to survivors, because to me it's, well, if you accept the premise of the law that somebody who was being trafficked at the time that they were convicted of this offense is not criminally responsible, why would we have a new trial? You should just vacate the conviction. And so this is the change in the law says that the judge shall vacate the conviction and state the reasons on the record. And that is actually something that can be helpful in pursuing other forms of legal relief. So for instance, if someone is trafficked in multiple states and there's a conviction in Maryland and a conviction in New Jersey and New York, I can now, I can actually provide the record of the hearing to the other attorneys in other states, and that can be additional evidence that the person was indeed trafficked because the judge stated so on the record. And one of the pieces of the law that we didn't show in the language in the previous slides is that these vacated convictions are now immediately expungible without a waiver. Previously, we had to get what's called a general release and waiver, essentially absolving the police department of any kind of responsibility for any civil violations that may have occurred during the time that the person was arrested, because we had to follow the general expungement rules for a nol pros or a dismissal. And the expungement form is actually going to be updated to state that another non-conviction that's immediately expungible is something that's been vacated under the True Freedom Act. So that's another great change, but it's a change to the expungement statute rather than the vacature statute. Okay.
All right, so there are some continued limitations of the vacature law that we do want to note, despite despite there being some great progress. And let's see. So one thing that we wanted to note is, sorry, I'm having a little trouble as we're noting we're sharing a mouse, and it can be a little bit challenging, as we all know, as we're doing remote work during this health crisis.
Yes.
So One important note again is this is only applying to convictions, and now, of course, not just for prostitution, but for the entire list of offenses that we shared with you earlier. And so if somebody has an arrest and the individuals pleaded to a lower alternative charge, they're not eligible for vacatur as of yet. And again, this goes back to what we were speaking about. If someone has a different type of disposition, but they were arrested for any of the offenses that were listed prior, there we're going to have to look for expungement as a remedy. It also, the current law does not allow the court to take additional appropriate action beyond the plain language of the statute. And other courts have a little bit more leeway because the vacatur law in their state is more broad and includes this language. So again, while there's been an improvement, we've gone from the court having incredible discretion about whether to hold a new trial or vacate an offense. Here, we still haven't reached that truly kind of full remedy where the court can take additional action if needed to make the survivor whole. The current law also does not provide a presumption of eligibility if official documentation is provided. And again, that's something that these are all things that we can continue to work for with new iterations of the law in the future if needed. I think one thing that we'll of course be looking at is, as Jess noted, we haven't practiced under this law, so we need to see how things go, what's working and what's not for survivors as we begin to file petitions for vacatur under this new law. There's also no explicit confidentiality provision contained within the new law. And of course, we, as a general best practice, we file under seal, but it would be neater and less complicated if, of course, there was an explicit confidentiality provision outlined. There isn't an automatic expungement of the arrest or the resulting non-conviction. And again, this is just putting that burden of the additional step of filing a petition for expungement on the survivor. And it's something that, we hope might be remedied in the future, but for now, it's important to keep that in mind. You can't just do the motion to vacate. You want to also include with that filing the petition to expunge the record and just fill in that it was vacated and that there's no longer a conviction after the judge makes a determination on that case. And finally, the law unfortunately does not include any funding for assisting victims with vacating their convictions. This is, we all know that legal assistance is critical for survivors of trafficking, and particularly with something as complicated or that can be as complicated as a motion to vacate, where you have to, often spend a fair amount of time working with a survivor to put down their story, gather all the corroborating evidence that you can. We hope that in the future there's going to be some dedicated funding that will assist with ensuring that survivors can access this remedy.
And Heather, just before we jump into additional 2020
Sure.
legislation, we are thrilled with this progress. It was hard fought, as I mentioned at the beginning. But I will just mention that it only brings our score up from an F-, because again, most people have heard me joke that if there were an F-, Maryland's law would have gotten that. So I like to use that. Not an F or an F+. It brings our F- up to a D. So there's a lot of work to do. But progress is slow, but we're making it, and this is a huge jump, and I'm so appreciative, but I'm not going to sugarcoat that there's a lot more work that can be done on this statute.
Mm-hmm. Yeah, I believe, we are so thrilled about the passage of this bill, and again, so in awe of the incredible survivor-led advocacy that made it happen. But it's true, there's always more work to be done, and we're always thinking about ways to improve criminal record relief and planning for the future.
Right.
So a few things that we wanted to note for you as well that also came out of the Maryland General Assembly session this year. And again, it was a very chaotic session with the health crisis, and a lot of times, it was hard to keep track of legislation. There was a lot of waiting to see what was going to be, passed, how it was going to be passed, and then of course waiting to see if the governor would be vetoing any particular legislation. And so we want to talk about just a few laws that we know will also impact survivors, particularly if there are some that choose to not go through with vacatur. And I've worked with survivors that have made that choice. The things on the record might have been eligible for both vacatur and expungement, and they chose to go with expungement because they didn't want to go through the process of preparing the vacatur motion. And these are all legitimate decisions, and they're based on what the survivor wants and what they're comfortable with and how much they want to dive into revisiting their past and telling their story. So one thing
that just highlights the importance of focusing on criminal legal relief in general as an anti-trafficking activist, because the more that there is that it is expungible, that's the more that my clients have access to make the decision of whether or not to vacate or expunge. And so all of these things, we can't sit in our silos and say the only thing that I care about is vacatur. No, you have to care about expungement too, because that opens up a far less burdensome avenue of relief. And so every time that we can expunge even the stuff that we can vacate, I'm thrilled to be able to offer that to clients.
No, we are as well. And with some of the things that were addressed at the General Assembly session this year, it is things that we've seen clients struggling with, even if they have been able to get a vacatur in the past. So one of the things that was repealed was the offense of common law sodomy and perverted practice. And I know Jess and I have both, through our programs, seen individuals who were trafficked who had this on their record, convictions for this on their record or arrests. And it's, to put in the words of one of the clients that I've worked with, she just said, it's an absolutely humiliating and horrifying thing to have on your record, because people don't even know what to think of some of these laws. What is perverted practice? What does that mean? And it really, can block a lot of people from being able to get jobs, move forward with their lives. And a lot of these laws were also, rooted in homophobia and in, other in other kind of problematic constructs that we're so happy are now slowly being addressed. So the result of this is, with the repeal of these two laws, anyone can file for an expungement of these convictions beginning October 1st, which is when the law goes into effect. And so that is, this is again a wonderful thing, not just for survivors that we're working with, but for the general population. And so please, as you're working with people, know that these are things that can be addressed, both through, expungement and with regards to practice through vacatur. Another law that was passed was a law that was addressing expungement options here in Maryland. And it included some things that we were excited about and also some things that we were hesitant about. One of the things that we were excited about was it would have opened up our ability to expunge fourth-degree burglary convictions, but it also contained a provision that stated there was going to be automatic shielding of all non-convictions. And you may wonder, why are we saying a boo to that? But one of our concerns is that if something is being automatically shielded, while it can be great in some ways, so that it's not accessible via Maryland judiciary case search to the general public, it can also make it very, very hard for individuals to find out information about their records and for attorneys to be able to look up and see what they need to, provide assistance with and what might be eligible for criminal record relief under the law. And these records would, even though they were shielded under this law, they would still be able to be accessible, by a lot of different types of organizations and agencies in other ways. So this law was vetoed by the governor, and we again look forward to seeing what happens in upcoming years to again do whatever possible to expand expungement to different types of convictions and to also make the process easier. But I think this law was just it caused us to reflect on how something that might initially be potentially beneficial can also make it harder for individuals to access relief.
Yeah. Heather, originally this was the goal of this law was to provide the option to do what we call partial expungement. So if I have, so as a unit of criminality, when I was arrested, I was charged with 4 offenses. I have 1 conviction and 3 non-convictions. Well, unless that conviction is eligible for expungement or some other form of relief, then those 3 non-convictions stay there forever. And so what advocates led by Out for Justice and Job Opportunities Task Force were focusing on was the ability to be able to petition to just expunge those non-convictions. Now, apparently, there are some challenges in terms of record keeping, and so they changed it to the automatic shielding and a partial expungement task force to try to figure out how to do that. But like Heather said, that automatic shielding makes it really problematic to go out into the community and to use case search to be able to expunge people's records.
Yeah, and again, the unit rule is something we grapple with, every day at MVLS, and I know, you do too, Jess, and with the clients that we're trying to serve, both survivors of trafficking and those that are not. And it would have been incredible if there would have been able to be that partial expungement. And again, we're looking forward to, joining with advocacy next year to try to have there be a good solution that allows that to move forward and yet doesn't set up these hurdles for people that are trying to assist people that can potentially, expunge things on their record.
I think we're heading in that direction.
Yeah,
we are.
Yeah. It's hard. It's all these things are difficult to wrangle and difficult to parse. So, all right. So I'm just gonna pause for a second. There's the option to submit questions through the question bar on the side of your GoToWebinar taskbar or menu. There's also the chat function. And so if anyone has any questions, please feel free to say them now. You can also, of course, always follow up with Jess or I via email or phone call. So I will just keep an eye on those 2 things. I'm not seeing anything right now. And I'm sorry, we realized during our, there is something, excuse me. Question, can you speak briefly on the progress regarding federal convictions of vacatur or federal convictions and vacatur for trafficking survivors? Justin?
Sure. Thanks so much for that question. The truth is, it's been minimal. We had the Trafficking Survivors Relief Act in 2016, and that really didn't gain a lot of traction. There was incredible amount of resistance from the Department of Justice. We had a similar version reintroduced in 2019, and it seemed like there was some traction, and then COVID hit. So we're in kind of a holding pattern right now, but I anticipate that will be kind of the next big frontier in getting some form of federal relief passed, because for those of you who are unfamiliar, there is expungement on the federal level, but in these 2 very minor minutia of circumstances, and not for the types of offenses that survivors of trafficking are being charged with on the federal level. Survivors of trafficking are overwhelmingly being charged with either trafficking themselves, conspiracy to commit a trafficking offense, or a Mann Act violation, basically taking individuals across state lines for some kind of criminal act. And again, these are disproportionately women of color that are charged alongside their traffickers. And there really is no form of relief available for them except for either requesting to get out of jail early, which is not a form of relief for their criminal record, but to seek clemency or to seek a presidential pardon. And we've submitted presidential pardons for survivors who were happy to be able to tell their story. And then I've worked with survivors who said, no, I'm not asking for permission for something that I wasn't criminally responsible for. So it presents this kind of, a kind of mental challenge for folks to say, like, do I try to get a pardon from the president, which is extremely unlikely, and in doing so, admit that I was wrong, or do I say, no, this is not for me. I was not criminally responsible. I was forced to commit these acts. and I shouldn't have been charged. So we really do need some kind of relief available on the federal level. And you know, we had some good traction. I actually think the law was fairly excellent, but we just got corona'd. Can that be a thing? That's pretty funny.
I think I probably will turn into a thing. Thank you for that question. And like I said, I'll be monitoring to see if any other questions arise, and we're happy to follow up after the webinar as well. So with that though, you know, I think we're about at the, we're 50 minutes in. So this will be going past the 1 hour mark, just so you're aware. I anticipate us being done, you know, well before 1:30, but you know, feel free to jump off at any time, especially those of you that might be more familiar with the process for filing a vacatur in Maryland. But we did want to take a minute and just go through this again in light of the new law and outline the steps you need to take, the new considerations you need to be thinking about, and really give a roadmap, particularly for attorneys that might be on the call who are interested in volunteering through MVLS to help survivors with this type of legal action. We are always looking for volunteer attorneys to help the Human Trafficking Prevention Project with all sorts of things: criminal record relief, vacatur, along with all other kinds of civil legal matters, including family law, consumer debt, you know, anything we work on at MVLS, we can assist trafficking survivors with. So this will be a good walkthrough to get you acquainted with the process and really give you the knowledge to be able to assist someone going forward if you're interested in volunteering. And for advocates on the call, I think it's great to just understand what the process is like, because we of course always encourage survivors that might be filing for vacatur, if they're interested in that, to have a support system in place, to be, you know, working with an advocate if possible, to be getting, you know, mental health and other supportive services if needed, because it, you know, it is a more involved process, and it's good to have that network set up. So with that, I'll hand it off to Jess to start talking about this.
Okay. So let's go through the legal elements of vacatur. The first one is it an eligible offense? Is the conviction eligible under the vacatur law? That being said, as I mentioned briefly earlier, if you know if you notice that there are convictions that lie slightly outside of our delineated list, please do contact us, because you know we have some additional considerations. But generally speaking, the conviction has to be eligible under the law. The person has to have the status legally as a victim of human trafficking. So does the client's experiences meet the legal definition of human trafficking? We also have to consider the nexus to arrest or conviction. Did the conviction arise as a direct result of human trafficking? Luckily, we have some additional considerations now with the True Freedom Act that can help define that direct result of human trafficking. And then obviously it needs to be timely. Has the motion been filed within a reasonable time after the conviction? Now that doesn't mean that if there's a conviction from 1990 that you can't file it now. It just has to be, you know, within the time period that the person kind of found out about this law. And so we've vacated convictions from the 80s, from the 90s. Allegedly, I have someone who may have a conviction here from 76. And you know, if folks don't know about the law and they don't have access to it, then there's no way for them to file it within a reasonable time. So that's really that reasonable time consideration. Okay, so when to file for relief? Hold on, I am struggling here.
Can you want me to take over, Jess?
Let me try one more thing. Okay, here we go. I am so tech fatigued.
As we all are.
I know. So the first consideration is, has the survivor been fingerprinted? Attorneys need to have the survivor's complete criminal record before legal options are discussed. And this is because the survivor may have used different names, different dates of birth, things like that. They may have been arrested in multiple states. So I don't want to just work on Maryland if the person has convictions in 9 other states. I want to be able to take a comprehensive approach to this and make those referrals as necessary. And the person probably has an inaccurate recollection of their arrest record. The criminal legal system is confusing, and purposefully so, and things are not always explained incredibly clearly especially if you consider the person was experiencing trauma or may have been arrested multiple times, or there may have been a great deal of time that has gone by before they're actually addressing their criminal record. So we really need their complete criminal record before legal options are discussed. Generally speaking, we will pursue expungement based on what's on Maryland Judiciary Case Search, but for something like this, we absolutely need them to be fingerprinted. And it's important to note that we will get the vacatur clients fingerprinted prior to making a referral to you, the pro bono attorney.
Mm-hmm. And we have funds for that, and I think
Yes.
it's also important for people to know that this is very common for us to look at Maryland Judiciary Case Search and then actually get the fingerprint record. And there's a whole lot of things that we didn't know about. It's also really important because so many of the clients that we work with have arrest convictions or open warrants in other states, and they might even not be aware of that. And we are able, a big part of both of our jobs is actually maintaining ties and connections to attorneys in other states, and we can make referrals and help them get those records addressed as well.
Yep. So once we know what's on the client's record, then we can kind of figure out what relief is available. But then the focus shifts entirely to the client, which is the survivor ready to go through the process? It often takes, as you advocates on the phone, on the webinar know, it can often take years or longer before someone is willing or able to work with an attorney or an advocate to address a traumatic situation. So like Heather said, this is not tops on anybody's list when a survivor is identified. The concrete emergent needs obviously outweigh this. And sometimes it takes a while to be able to right the ship in order for a survivor to be willing or able to work with an attorney to seek this form of relief. Survivors obviously have often experienced multiple forms of victimization, trafficking not being the only one. And so there's a lot of moving parts, and this process is heavy. So someone really just has to be ready to go through this process. It's also essential that the survivor is driving the process, because regaining control is crucial to healing from trauma. So if the survivor is not ready to do this, then that's fine. You know where to find us. But it's essential that the survivor is in control of this process. As attorneys, we have to have really frank discussions of the benefits and the challenges, the time frames, things like that. Sharing your story, not multiple times, but sharing your story and documenting it, and having a state's attorney read it, and having a judge address it, and having the process take some time. We really need to talk about those challenges as well as all the benefits that we all already know. And to that point, the attorney and the survivor should proactively identify the forms of support available to the survivor and make referrals as appropriate. When I train students to begin their interviewing process with a client that they're going to seek vacatur for, one of the first things we ask is, when you are feeling stressed or angry or scared or experiencing, traumatic recollections, what do you do and where do you go? And we proactively identify those things so that if the client is experiencing, a traumatic reaction to sharing this material, or struggling with other issues in their lives, that that support is proactively identified for them. So again, when to file for relief. So we've gotten them fingerprinted, survivors on board, we've done the work, right? We've put together the vacatur motion. While the state's attorney's consent is no longer required in Maryland, as I stated in a couple slides earlier, working collaboratively with prosecutors is a best practice. It really is incredibly healing, or can be incredibly healing, I should say, for survivors to be able to go through this process, knowing that they have the support not only of their attorney, but of the prosecuting body, the person who chose to file charges and who pursued charges against them. It's really can be incredibly healing. So if you are assigned a case in a jurisdiction where relationships have not yet been formed with the state's attorney's office, and we're hoping to, we're hoping to expand our reach in the coming years, and so we anticipate that this kind of thing will happen more and more. But in jurisdictions where there is no current relationship with the state's attorney's office, just contact us for assistance in beginning this process, and we'll work with you to make that happen. And once these connections have been made, you are going to approach the state's attorney with the intent of working collaboratively. You explain what you've learned about the survivor that their office could not have known at the time that they chose to prosecute the survivor. And then you can, but obviously with the permission of the survivor, you can offer in-person meetings, or you can link the prosecutors, or we can help you link to prosecutors in other jurisdictions who are incredibly supportive of the process. And we know several of those in several states, and that can be incredibly reassuring for prosecutors. So what's included in a motion to vacate? We're going to talk, Heather's going to go through this in greater detail, but essentially you're going to talk about the affidavit of the survivor. So that is the survivor stories. It's a sworn statement of their story. And again, Heather will explore that in greater detail. There's an attorney affirmation, which essentially is me swearing that the materials that I'm submitting to the court are true to the best of my knowledge. There's a memorandum of law that highlights why the survivor meets the legal definition for trafficking and how we have done our part in making sure that the elements of the vacatur law have been fulfilled. And then any corroborating evidence that we can actually produce but is not required, but that supports all of these different pieces of the moving papers.
Great.
Okay.
So going a little bit more in depth about constructing your client's narrative in preparation for filing the vacatur petition, one of the first things that we always recommend is creating a timeline. It can be really grounding for the survivor and for yourself as the attorney who's working on this matter, and give you that outline to begin filling in. It's, you know, as the slide states, it's just really critical to help the survivor kind of organize what's happened to them. As Jess mentioned earlier, and as we discussed in depth on an earlier webinar that we did looking at the impact of trauma, it can be very, very difficult for survivors to remember details about their experience, to remember, you know, dates, you know, locations, particular things that we want to, of course, include as much of as we can in the affidavit that we're creating. So creating some sort of timeline is really useful, and we often start by, you know, using documents. Like, what documents do we have? Do we have, you know, records of old addresses? Can we look through even something as simple as looking through Maryland case search and you know, identifying any criminal records that the survivor has and looking at like addresses and associating them with dates, and that can begin to create this timeline that you can use to then fill in with the survivor. So again, you can start with the timeline that, you know, looks at the convictions, or sometimes, and this just depends on your own personal, you know, decisions and what you think might work best with the survivor that you're currently working with. Sometimes it's good to start, you know, again with convictions, but sometimes I've actually just started from the beginning. Like, ask the survivor to talk a little bit about their childhood, what they remember growing up, if there were any, you know, any incidences that they wanted to share with me. There's pros and cons to doing this. Sometimes, you know, if somebody's been is a survivor of abuse or neglect during their childhood, it can be very difficult to talk about those memories, and you might need to build up a little bit more of a relationship with the survivor before they're comfortable telling you those things. But these approaches are both things that you can try as you're trying to construct that narrative. And again, this is another great piece of advice. You know, many of the clients that we're working with that get referred to MVLS and to University of Baltimore are already working with advocates, and they may have already put down some kind of narrative or timeline. And so if, you know, we always try to ask if there's any materials that we can use to help us get started with helping the survivor tell their story. And if there's anything that makes us not need to ask those detailed questions, which can be re-traumatizing, we of course want to use that, you know, as kind of a grounding for our timeline and for the narrative.
And, you know, just a quick kind of example of that is we just got a call from an advocate in New York who's working with a survivor on a T visa who has a conviction here in Maryland. And so it's very easy for her to be able to give me the narrative from the T visa, and then all I'm going to have to necessarily tease out is the material around that conviction in Maryland, and that avoids the survivor having to tell their story to 50,000 people.
And I don't think any attorney should feel like they have to, go over every detail again to verify that if it's already been verified with another attorney, an advocate. Like,
Exactly.
we can do it at a higher level. And again, just avoid anything that might be re-traumatizing. And this leads into our final point that, again, the client controls the content. When I'm working with survivors, and I know Jess does this too, there may be details that they do not want to include. There may be, and our job as attorneys is to tell them what might be relevant to the law, relevant to the remedy that they're trying to seek, but also not push for things that are, just extraneous to that, right? Like, we aren't here to write a novel. We're here to show how someone meets definition of human trafficking and to show a nexus between that experience and the conviction that we're trying to vacate.
And I say to my students, if you don't have a legal reason to ask the question, don't ask it.
Yes, that's a really good tip. So just thinking about what that outline is going to look like, you want to include some information about the survivor's experience before their trafficking experience, discuss their background, and things that are relevant to this form of relief is, looking at the survivor's specific vulnerabilities. As I mentioned earlier, have they been subject to abuse or neglect? Was there other type of instability, housing instability, homelessness, other things in their life where their parents or they or family members or community members struggling with addiction? Does immigration status play into their narrative and impact their stability? There's a lot of things that is informative for the court to know about, but again, survivors driving this information, and it's up to them to control the content. These are things you might want to think about, ask some questions about, and potentially ultimately include in that affidavit. Now, of course, detailing their trafficking experience is the core of what we need to present to the judge. So it is very important to have as much information as possible about how the survivor met their trafficker, how the trafficker used force, fraud, or coercion to obtain control of and exploit the survivor. And again, this might be, and often is, a longer story where maybe that force, fraud, or coercion was not there at the beginning, but it is something that eventually began to manifest through time, and that the survivor began to experience the longer they had a relationship or were interacting with the person that became their trafficker.
And that's actually a really kind of key piece of law. The TVPA states that initial consent, let me start that over. Initial consent, initial consent to the form of labor does not precede someone becoming a trafficking victim if and when force, fraud, or coercion is used to maintain them in doing that form of labor. So if you ever hear that story, just understand that the law backs you up, that is still trafficking.
And again, I think that also speaks to what many survivors have experienced. It's not this sensational kidnapping and someone's, forced to do something against their will. Oftentimes it's, the abuse and the trafficking and the coercion and the force is coming from somebody that initially the survivor might rely on or trust or see as a resource or an ally or someone that's providing them with something that they didn't have before in their life. And so it is very important to go into that story in detail and get that down. And then, of course, you want to be focusing as well on the survivor's post-trafficking experience, how they've connected with services, talk about what they're aspiring to do, what they're hoping to accomplish in their life, and then put that in context of how these convictions that they have on their record are presenting obstacles to them achieving those goals.
And it's important for those of you who have never seen a vacatur kind of motions packet. Those are available on MDLS's website as well. Some redacted affidavits, attorney affidavits, and memorandum of law, so that you're not flying blind here. You can look through that, and it's once you read one for the first time, it's much easier to kind of conceptualize how you want to ask your questions.
Yes, and just to note, the current materials that are up on MBLS's website are still relating to the prior version of the law, and we are working on adapting and getting some new examples up for different situations involving petitioning for vacatur that now we have under this new law. So we will keep everyone posted as those go up on our website, which will also, our website will also be getting an update soon too, which is very exciting. So now we're going to just quickly turn to gathering corroborating evidence. As you're thinking, about all of the things that you can potentially include in this petition, it's important to think expansively. Of course, the grounding document is going to be that survivor's story. That firsthand account that's in the affidavit that you've worked on so hard with the survivor to make as detailed as possible and to, again, really meet all those legal elements that you'll be using to argue in your motion. And of course, I would be remiss if I didn't point out that, technically all you really need is the affidavit. I mean, that can be enough if you don't have any other corroborating evidence to get that vacatur granted. But of course, if you can find other things, that's very useful as well. So you're going to create the affidavit with the survivor, then look to other official documentation. So this is a long list of things. But official documentation carries a certain weight, and of course anything that might come from immigration proceedings, from Housing and Human Services. If somebody has received a T visa or a U visa, which again is a legal acknowledgement from a federal court, they meet the definition of a trafficking survivor in the case of a T visa, or a victim of certain crimes for a U visa. That's incredibly useful to include with your motion. And of course any other court records that might demonstrate survivor status as a trafficking victim. If the survivor's pursued getting damages, if they have received vacatur in any other jurisdiction here in the United States, if the trafficker was prosecuted and the survivor you're working with participated in that prosecution, or not. These are all very useful records to include. And we can help you think expansively about this too. And a lot of these kind of leads for these things will come out as you're talking to the survivor and you're building that affidavit. So there's also a lot of other corroborating evidence that can be included. And again, you want to think very expansively. If the survivor, was a victim of abuse or neglect as a child, are there any records of that? Are there medical records? That's something that we always look for, and sometimes it can be hard to obtain, particularly if the trafficking experience was a while ago. Hospitals and doctors might not be holding onto records for as long as, for privacy concerns, for as long as you might expect. But it's always worth asking. I recently got some records for a survivor that were they were nearly 20 years old, but they're still there and they're able to bolster her case. If there's any photographs the survivor might have, if there's any photographs of tattoos or scars that might be related to the trafficking experience, internet listings. And then, again, this is very important for advocates that are listening on the call. We also love to include letters of support from therapists, from other service providers, from community leaders. If the survivor is going, attends a church or a synagogue or wherever, it can be very important to have those additional letters of support to bolster the survivor's case. Again, the bottom line, be creative.
Okay. Whoop. Okay, so once you've done all of these things, you've gotten the fingerprints, you've gotten the buy-in from the survivor, you've done all the work, you've put all the things together, you want to start communicating with the state's attorney to have them review the motion to vacate and hopefully obtain their consent. So you want to submit the completed motion to the SAO for review. If you've been able to obtain consent, you're obviously going to file the motion and this brand spanking new vacatur form that we'll show you in the next slide, and certificate of service with the court. If consent has not been obtained, you're going to be preparing for a hearing. And obviously that is a whole nother webinar. We're not going to go into that today. Once you filed, you want to make sure to get a courtesy copy to the SAO so they have it for their records. You're going to request to file under seal, which is Maryland Rule 16912, and there is a separate form that goes with that you have to submit with all of this, because technically what they have to do is rule on the motion to seal and then the motion to vacate. If you're unable to file under seal, you're going to want to request that the survivor's personal information be redacted in all public court documents. You can consider filing as a Jane Doe. And something to think about is if the survivor that you're working with is involved in the prosecution of, that should be their trafficker, that is a major typo for me, consider filing a motion containing minimal details. And I've done this before, so if that's happening, or if the survivor is involved in any court hearings, make sure that you're communicating with us, because obviously any inconsistencies in court records can be problematic for the survivor. But since we've done this in the past, make sure to contact us. Then you're going to want to proactively prepare expungement paperwork to address, the vacated conviction or convictions, and submit that to the judge or the court immediately following the hearing. I've been successful in getting the judge to actually also sign off on the expungement paperwork, and I have not, in which case I just go downstairs to the clerk's office and file it. And again, just remember that there's no need for that general waiver and release, because the new expungement forms will have a checkbox that says the conviction was vacated pursuant to 8-302.
Jess, a quick question. So now under the new law, since if you receive that consent, you may not even need to have a hearing if that's what the survivor would like. Do you think you should just include those expungement documents in the overall packet sent, or?
Yeah, I think that might be a smart way to do it.
Yeah, I mean,
actually haven't thought about that.
Yeah, we can always think a little bit more about that, and we'll be posting on our website kind of a comprehensive list of everything that should be incled, again, with the
I think it's a good idea.
Yeah.
And if judges are confused, their clerks will call us. Like
exactly. We hope.
Might as well try it. I always feel like if you try and you strike out, you weren't in any worse place than you were to begin with. I still have to just file with the court. So this is the brand new motion to vacate judgment of conviction. So I moved to vacate the judgment of conviction in the above captioned case. I was convicted as a result of being a victim of human trafficking. Check all that apply. And since it's one per case number, every case that you're seeking to vacate, you're going to have to fill out one of these. And describe the evidence showing that you're entitled to relief. Obviously, that would be attached moving papers, and then there's the certificate of service down below. Okay, so that's our new form. We just got notice of that on the 1st. I got that sent to me. So we don't know it that well either, but we know that it's pretty clear case number, one per case, but then it can be one set of moving papers per number of cases. So some special circumstances to consider. We're going to be wrapping up soon. Are convictions occurring after the survivor exited the trafficking situation? So a lot of survivors continue to get arrested for crimes that are directly related to their trafficking, despite the fact that they've already fled. And every effort should be made to include these convictions in the client's vacatur motion by explaining that kind of 3-part nexus, relationship to the trafficker, and any other relevant evidence, as the court must explicitly consider these factors. And again, you try, and if you swing and miss, they're not in any worse position than they were. And then perhaps you can consider additional forms of relief like expungement. Another special, well, actually a continuation of that special circumstance is some examples of clients who continue to face arrest, clients who are homeless as a result of their trafficking experience, either because they fled their trafficker or they're living on the margins to escape detection by their trafficker, clients who were still struggling with, coping with what they've been through use of substances, clients who can continue to engage in sex work, either because it's the only way they know how to survive, or reinforces the message that they've received that trading sex is all they're good for, or that that's what they've done in the past. And, there's nothing that in this law that says someone has to be quote unquote rehabilitated. We understand that, recovery from trauma and healing is a continuum. And so it is really common for folks to continue to trade sex after they've exited their trafficking situation. And obviously clients who cannot or believe they cannot work in the legal economy. those folks are going to continue to struggle with poverty-related offenses. Convictions as a minor. We're not necessarily seeing this in Maryland, but it is pretty common in some other states for victims of trafficking to be charged as and convicted as minors. Victims may give a fake date of birth, either in an attempt to escape detection by the child welfare system or because they were instructed to do so by the trafficker. So some victims are convicted as adults even when they do disclose their status as a minor. I've never worked on a Maryland case like this, but I've worked on a case with a survivor in Maryland who had a conviction like that in another state. And it's important to note that because any minor engaging in commercial sex acts is considered a victim of sex trafficking per se, these motions are usually fairly straightforward and don't require all that much legwork. And obviously contact us if this becomes an issue. Vacatur and immigration. Do not begin work on a vacatur petition on behalf of an undocumented survivor unless you are working in consultation with an immigration attorney. And we really just want to make sure that we are pointing out that this is crucial. So immigration attorneys are needed to think through immigration consequences, to advise how to craft the vacatur order so that it doesn't harm the client's immigration options, and then to review the final motion through an immigration lens. So it is crucial to collaborate with an immigration attorney if you are working with a survivor who is seeking immigration relief. Multi-jurisdictional practice. As we've mentioned several times, many survivors have trafficking-related arrests or convictions in multiple counties or states, and separate motions have to be filed in each jurisdiction where they've been convicted. And it's really important to think of a strategy when you get that fingerprint record for placement of cases, and that needs to be done at the outset. You have to consider whether the order that you file these multi-jurisdictional motions will positively or negatively impact eligibility in another jurisdiction. And that kind of draws us back to the map, that every jurisdiction has a different law. And so if you're working in one of these multi-jurisdictional practice cases, you're going to get up to date on other states' criminal record relief laws very, very quickly. This process takes a long time because you're not dependent on your work product. You're not dependent on the speed of things here. You're dependent on that perhaps in 9 other states. And so the attorney really has to manage the client's expectations with regard to this process. I think the one that I've worked with clients with convictions between 7 and 9 different states, and it's a haul, for lack of a better word. Reach out to us or to the Survivor Reentry Network for assistance with making these referrals to other states. We're developing a pretty great group of attorneys that are able to take these cases.
And just a quick note on that last slide, for any pro bono attorneys that might be listening or people interested in volunteering with MVLS, we do not expect you to take cases in multiple jurisdictions outside of Maryland. That's where coordinating with myself and of course Jessica is part of our team to really we'll look at everything comprehensively once we get those fingerprint records, and oftentimes we may have an attorney handling the Maryland casework that's through MVLS's pro bono network, and then we're connecting the client with other attorneys in other jurisdictions. Now, if you're from a big firm, if you have additional resources, you're burdened in other states, and you are willing to take on a multi-jurisdictional case across,
by all means, do so.
By all means, we are really excited, and we will provide resources and guidance. But I just want to also, not overwhelm people that this is not something that would commonly happen or that we would look for unless you were volunteering to take on such a weighty matter.
Right. All right, convictions occurring after the survivor has already had prostitution convictions vacated. So these are for folks who have already, accessed relief under the old statute, but now you realize that they have other convictions that now can be vacated. So obviously contact us immediately because we are in the process of developing an updated order and an updated attorney affidavit, and the attorney affidavit will reference the additional convictions and also reference the previous vacatur order and moving papers. The goal with this is to make it not the heaviest lift where you have to, add all this material to the memo of law and add all this material to the affidavit and that kind of thing. That instead it will be in the attorney's voice, referencing the things that are already pre-existing in the case and submitting all that together. And that's what we developed in consultation with the state's attorney. So we're in the process of actually updating, as luck may have it, the moving papers that are on MVLS's website. The client has both a prostitution conviction and an arrest for drug possession. So we're just going to kind of use that still as a model case and update the order in the attorney affidavit for part 2 of her vacatur petition. That being said, obviously, still make an effort to collaborate with the state's attorney. That should be a relatively less heavy lift than it was at the beginning. But the state's attorneys do know that this is happening, and they, we've talked to, especially our contact in Baltimore City, that we have a number of cases that are going to be coming back around the pipe to them to vacate additional convictions. And then just always supporting survivors is at the forefront of everything that we do. And survivors may have behavioral health needs, need for addiction services, crisis assistance, additional legal assistance, medical care, employment assistance, immigration assistance. And so to make referrals for supportive services, we are there to help you with that because we want to make sure that this process, that survivors are supported through this process, and that this is ultimately an empowering experience for them.
Well, thank you so much to the many of you who have stuck with us through this long presentation. Again, we're just having discussions about how we have to officially reschedule our webinars to be going an hour and a half, since they all seem to run long lately. But we hope you're finding this information valuable. And again, if you are interested in helping with these cases, please reach out to me directly, and we look forward to talking to you further about getting involved. We will be sending out a post-webinar survey. We do look at the answers, so please take a moment to fill that out. And just a quick housekeeping note, Maryland Volunteer Lawyer Service is still open, and our intake lines are still operating. They have been throughout this entire health crisis, even though we are not currently in the office. Everyone is working remotely, but the office will be partially reopening on June 8th. And of course, we will be taking cues from the Maryland government as to whether we'll be, and the court system as to whether we'll be remaining open, opening more, or closing again. For now, though, people can feel free to direct potential clients to do online intake or call our phone intake lines. And of course, if you are working with a survivor or someone that you think would fall under the Human Trafficking Prevention Project as an individual who is vulnerable to future exploitation, you can reach out to me directly to make a referral. My contact information is at the end of the webinar. Please do follow us on social media for important updates, not just about MVLS, but about community resources throughout the state that might be able to assist you, your clients, your neighbors. We are always looking for volunteer attorneys. And if you are already a volunteer, I think you know where to find pro bono cases. We list them on our pro bono portal, though I will make a note that many cases coming through the Human Trafficking Prevention Project are assigned personally by me to attorneys that I've spoken to and that have joined our HTPP volunteer panel. So if you would like to work on HTPP cases, please reach out to me, Heather, directly. All right, and if you're not a volunteer, you can sign up today. Here's a link to our form. You can also just go to mvlslaw.org to sign up on our website. And if you are interested in volunteering for the HTPP, if you check that box on your volunteer form, then I will follow up personally to have a discussion with you about the program and the ways that you can get involved. We do try to provide a robust training and education schedule, particularly as we're not doing in-person training and outreach at this time. So please do check out our calendar for information on more events. We have a number of great presentations coming up in June. One I would particularly like to highlight is on June 10th, there's going to be a webinar on emotional resilience during the COVID-19 pandemic, and that is in partnership with the Maryland State Bar Association. I encourage everyone to attend. And with that, again, you can access additional past recorded trainings. We have been doing a quarterly webinar series here through the Human Trafficking Prevention Project, in addition to some additional webinars for the last 2 years. And so we have quite a library if you would like to learn more about the intersectionality of tax law and human trafficking, immigration law and human trafficking, as well as a plethora of other topics. So please visit our website for more information and to view those videos and access those resources. With that, I will just say a huge thank you to Jess for sharing her incredible depth of knowledge during this presentation. And here is our contact information. Thank you, attendees. Hope everyone stays healthy and safe. And please feel free to reach out to us if we can answer any questions or assist anyone that you know that might benefit from this new vacature law.
Stay safe, all.
Thank you.